Welcome CA Foundation students. Today we are going to discuss about the nature of contracts from Indian Contract Act 1872, in which we are going to cover the topics proposal, offer, acceptance, agreement, communication and revocation. And we will also be discussing the studies which will be helpful in understanding concepts much better and also to crack those concepts in exams. So let's dive in. The Indian Contract Act is a significant piece of legislation that governs contracts and agreements in India. The Indian Contract Act lays down rules and principles governing the formation, performance, and enforcement of contracts. It ensures fairness, clarity, and legality in agreements between individuals, business, or other entities. For example, suppose you purchase a smartphone from an online retailer. The transaction involves an agreement between you and the retailer. The terms of this agreement, such as price, delivery, and warranty, are governed by the Indian Contract Act. Now let us look at the important definitions under this act. First one, proposal. It refers to an expression of willingness by one party to another with the intention of obtaining assent from the latter. It forms the basis for initiating a contract. When one party offers to sell a product or provide a service to another party, it constitutes a proposal. The terms and conditions laid out in the proposal serves as the starting point for negotiation and agreement. For example, if A offers to sell their car to B for 5 lakhs rupees, A is making a proposal to the B. The offer to sell the car at a specified price constitutes a proposal under the Indian Contract Act. Now let us look at the definition of acceptance. It occurs when the offeree agrees to the terms of the proposal made by the offerer. It is an essential element in the formation of a contract. It indicates the willingness of the offeree to enter into a contractual relationship with the offerer. For example, if B agrees to purchase a car for 5 lakhs as proposed, B's agreement constitutes acceptance. By accepting the offer, B acknowledges and agrees to the terms laid out by the A. Now let us look at the definition of agreement. An agreement comprises promises exchanged between parties, forming the basis of a contract. It involves mutual consent and understanding between the parties involved. An agreement arises when one party makes an offer and the other party accepts it, thereby creating mutual obligations. It represents the meeting of minds between the parties to the contract. Suppose A offers to sell their house to B for 1 crore rupees and B accepts the offer. This exchange of offers and acceptance forms an agreement between A and B, laying the groundwork for a potential contract. Now let us look at the definition of void agreement. It is one that lacks enforceability by law. It doesn't create any legal obligations on the parties involved and is deemed invalid from the outset. Certain agreements are considered to be void under the Indian Contract Act due to various reasons such as illegality, impossibility, or lack of free consent. These agreements are not recognized by law and are therefore unenforceable. Example, an agreement to commit a crime or engage in illegal activities such as smuggling goods would be considered void under the Indian Contract Act. Such agreements are against public policy and cannot be enforced by law. Now let us look at the definition of contract. A contract is a legally enforceable agreement between two or more parties. It entails mutual promises, obligations, and considerations, giving rise to legal rights and remedies. Unlike mere agreements, contracts are binding and enforceable by law. For example, when A agrees to sell their car to B for 5 lakh rupees and B accepts the offer, a contract is formed between A and B. Both the parties are legally obligated to fulfill their respective promises, and failure to do so may lead to legal consequences. Now, is every agreement a contract? While every contract is an agreement, not every agreement qualifies as a contract under the Indian Contract Act. To constitute a valid contract, an agreement must fulfill certain elements, including offer, acceptance, consideration, intention to create legal relations, capacity to contract, lawful object, and free consent. An agreement that lacks any of these elements may not be enforceable by law and therefore does not qualify as a contract. Example, suppose A promised to donate 1000 rupees to charity organization without expecting anything in return. While this constitutes an agreement, it does not meet the requirement of consideration and therefore cannot be enforced as a contract. Now let us look at the elements of a valid contract. A valid contract must satisfy certain essential elements to be enforceable by law. These includes first one, agreement. There must be a valid offer by one party and acceptance of that offer by the other party. Second one, consideration. Something of value must be exchanged between the parties. Third one, intention to create legal relations. The parties must intend to create a legally binding agreement. Fourth one, capacity to contract. The parties must have the legal capacity to enter into a contract. Fifth one, free consent. The consent of the parties must be free from coercion, undue influence, fraud, misrepresentation, or mistake. Sixth one, lawful object. The purpose of the contract must not be illegal, immoral, or opposed to public policy. Sixth one, lawful object. The purpose of the contract must not be illegal, immoral, or opposed to public policy. Seventh one, certainty. The terms of the contract must be clear and definite. Eighth one, possibility of performance. The performance of the contract must be possible and not dependent on uncertain events. Each of these elements is crucial for the validity and enforceability of a contract. Failure to fulfill any of these requirements may render the contract void or voidable. For example, consider a scenario where A offers to sell their car to B for 5 lakhs rupees and B accepts the offer. Both parties agrees to exchange the car for the specified amount of money, intending to create legally binding agreement. This constitutes a valid contract under the Indian Contract Act. Now let us discuss about the topic offer. An offer is a proposal made by one party to another party, expressing their willingness to enter into a contract under certain terms and conditions. Offers are the starting point of contract and must be clear and definite and communicated to the offeree within the intention of creating legal relations. For example, suppose A offers to sell their laptop to B for 30,000 rupees. This offer is communicated clearly to B, indicating A's intention to enter into contract with B under the specified terms. Until B accepts the offers, no contract is formed. Types of offers. General offer. An offer made to the public at large, inviting anyone who meets the terms to accept. Example, advertisement offering discounts on products to all customers during a sales period. Specific offer. An offer made to a particular person or group of person. Example, A offers to sell their car to B for a specific price. Next one, express offer. An offer made explicitly either orally or in writing. Example, A's written offer to sell their house to B. Implied offer. An offer inferred from the conduct or circumstances of the parties. Example, placing an order in a restaurant implies an offer to purchase the food. Now let us discuss about essentials of valid offer. It should be clear and definite terms. The terms of the offer must be clear, specific, and capable of being understood by the offeree. Example, A's offer to sell their car for 50,000 with clear specifications of the car's make, model, and condition. Second one, communication to offeree. The offer must be communicated to the offeree or brought to their knowledge. Example, A must inform B about the offer to sell the car before B can accept it. Next one, intention to create legal relations. The offerer must intend to create a legally binding agreement. Example, offers made in jest or social invitations are not intended to create legal relations. And the next one, non-containing negative conditions. An offer cannot impose negative conditions on the offeree. For example, an offer stating, if you do not reject this offer by tomorrow, it will be considered accepted, contains a negative conditions and it is not valid. Now let us discuss about the topic acceptance. Acceptance is the assent or the agreement by the offeree to the terms of the offer made by the offerer. It is a crucial element in the formation of a contract. Acceptance indicates the offeree's willingness to be bound by the terms of the offer, leading to the formation of a contract between the parties involved. Example, if B agrees to purchase A's laptop for 30,000 as offered by A, B's agreement constitutes acceptance of the offer. This acceptance binds both parties to the terms of the contract. Now, essentials of the valid acceptance. It should be absolute and unqualified acceptance. Acceptance must be absolute and unconditional, agreeing to all the terms of the offer. For example, B agrees to purchase A laptop for 30,000 without proposing any changes to the offer. Next one is communication of acceptance. The acceptance must be communicated to the offerer either expressly or impliedly. Example, B informs A of their acceptance of the offer to purchase the laptop. Next one is mode of acceptance. The acceptance must be made in a manner specified by the offerer, or if no mode is specified, in a reasonable manner. Example, A's offer specifies that acceptance must be made in writing. B must communicate their acceptance in writing. Acceptance must be given within the time specified in the offer or within a reasonable time if no time specified. For example, if A's offer states that acceptance must be made within 3 days, B must accept within the same time. And next we discuss about communication and revocation. Effective communication and timely revocations are essential aspects of contract formation. Communication of offer and acceptance must be clear and timely. Revocation of offer and acceptance may have legal implications, must be done in accordance with the law. For example, if A offers to sell their house to B and communicates the offer clearly to B, B must communicate their acceptance or rejection of the offer within a reasonable time. Similarly, if A decides to revoke the offer before B accepts it, A must communicate the revocation to the B. These are all the concepts which we are going to look. Now let us look at the case studies such that we will get a good understanding of the concepts what we have learned. Case study 1. Suppose A offers to sell his car to B for 3 lakhs. B, after considering the offer, agrees to purchase the car at the specified price. However, before B communicates his acceptance to A changes his mind and decided to withdraw the offer. B is unaware of A's decision to revoke the offer and proceeds to communicate his acceptance to A. Analyze the situation according to the provisions of the Indian Contract Act and determine the legal consequences of A's withdrawal from the offer. In this scenario, we have a situation where A made an offer to B to sell his car for 3 lakhs rupees. B, upon receiving the offer, intends to accept it. However, B communicates his acceptance to A. In meantime, A decided to withdraw or revoke the offer. Subsequently, B communicates his acceptance to A, unaware of A's withdrawal of the offer. According to Indian Contract Act, an offer can be revoked at any time before it is accepted, provided that revocation is communicated to the offeree. In this case, A's withdrawal of the offer is effective only if it is communicated to B before B communicates his acceptance. Since B was unaware of A's decision to revoke the offer and proceeded to communicate his acceptance, a valid contract is formed between the A and B. A's withdrawal of the offer after B has communicated his acceptance does not affect the formation of contract. A is bound by the terms of the offer he initially made and B is entitled to enforce the contract against A. Consequently, A is obligated to sell the car to B for 3 lakhs rupees as per the terms of their agreement. In conclusion, A's withdrawal of the offer After B's acceptance does not invalidate the contract formed between them. Now A is legally bound to fulfill his promise to sell the car to B, and B can enforce the contract against A to procure the car at the agreed prices. I hope this video is informative and helpful in clearing the concepts of nature of contracts. If you have any issues, please do comment or share your questions to our mail ID. Thanks for watching.